The dispute we will discuss this afternoon, City of Boerne, Texas v. Flores, which the Supreme Court will hear tomorrow morning, is a case in point. However complex the underlying issues, the dispute arose quite simply, but today all too commonly, when the Archbishop of San Antonio, P.F. Flores, sought a construction permit from the City of Boerne, Texas, to tear down a local church and build a new one. That the Archbishop could proceed only with government permission tells us already that we are in the 20th century. That the permit was denied under local historic preservation laws tells us that we are well into a century that permits change only when it conforms to some massive government plan. When the permit was denied, Archbishop Flores sued, invoking the Religious Freedom Restoration Act, or RFRA, which Congress had passed in 1993. In defense, the City of Boerne claimed the act was unconstitutional because it violated the separation of powers. Here the issues start to get complicated, but it's important to outline them if our discussion is to make sense. RFRA was signed by President Clinton on the South Lawn of the White House with great fanfare and broad bipartisan and ecumenical support. The act was a response to a 1990 Supreme Court opinion in the case of Employment Division v. Smith. In that opinion, the court abandoned the strict scrutiny it normally invokes in cases involving religious freedom, itself a vexing issue, and applied a middle level of scrutiny to find that the state of Oregon could deny unemployment benefits to Native Americans who had been fired from their jobs after using illegal peyote as part of their religious rituals. The court held that there is no special religious exemption from neutral, generally applicable laws that happen to have an incidental effect on the free exercise of religion. Thus do drug laws, as well as zoning and many other laws, intrude upon religious freedom. But the issue here is not simply what laws may or may not so intrude constitutionally. It is also a question of whether Congress has the power under Section 5 of the 14th Amendment to displace state laws, and if so, on what grounds, a federalism question. And it is a question also, perhaps more vexingly, of whether Congress has the power to intrude upon the court's interpretation of the Constitution by requiring a higher standard of review for religious freedom cases than the court has used, a separation of powers question that takes us back to 1803 in the seminal case of Marbury v. Madison. Finally, adding still another level of complexity, though one not directly at issue in Boerne, even if Congress had the power to enact RFRA as applied to the states pursuant to Section 5 of the 14th Amendment, by what enumerated power could Congress enact RFRA as applied to the federal government? To help us sort those questions out in greater detail, we're fortunate today to have with us two people who have given the issues a great deal of thought, even if they have reached different conclusions on the case before the court. Each of our speakers will have 20 minutes to state his position, after which each will have 5 minutes for a rebuttal. We will then take questions from the audience, which will be followed by lunch in our winter garden upstairs. Let me introduce Marcy Hamilton first, and then Kevin Hassan just before he speaks. Professor Marcy Hamilton is professor of law at the Benjamin N. Cardoza School of Law, Yeshiva University, where she specializes in constitutional and intellectual property law. She's written widely in the areas of First Amendment, copyright law. She is currently writing a book on the influence of the Presbyterian Church on the formation of the United States Constitution. During 1997-98, she will be a fellow at the Center for Theological Inquiry and a visiting scholar at the Princeton Theological Seminary. Professor Hamilton clerked for Associate Justice Sandra Day O'Connor of the United States Supreme Court and Judge Edward R. Becker of the United States Court of Appeals for the Third Circuit. She received her J.D. from the Pennsylvania Law School, magna cum laude, University of Pennsylvania Law School, magna cum laude, where she served as editor-in-chief of the University of Pennsylvania Law degree. She also received her M.A. in philosophy and with high honors from Pennsylvania State University, and her B.A. summa cum laude from Vanderbilt University. She is currently lead counsel for the City of Boerne, Texas, in the case challenging the constitutionality of the Religious Freedom Restoration Act, and she will argue the case tomorrow before the United States Supreme Court. Would you please join me in welcoming Professor Marcy Hamilton?
like to thank Roger and especially Tim Lynch, who organized this, and the Cato Institute for organizing this important event, which I hope will reach an audience that, as of yet, does not know about the constitutional crisis that is called the Religious Freedom Restoration Act. If upheld, this act will transform this society from one in which churches are expected to be fair-minded members of their respective communities to one in which churches hold the upper hand, whether the issue is zoning, prison regulation, or taxation. Its disdain for the rule of law and for a responsible role for churches is certain to engender less rather than more religious intolerance. It has been unfortunate that it was drafted in such legalistic terms, a standard of review, and therefore has been largely inaccessible to the people who are the ones who should understand what has hit them. Now let me provide a bit of background to RFRA before I go on to explain why I think that it is patently unconstitutional. In a lighter note, let me just say that last night, or 2 nights ago, I was informed that I was the respondents in this case' worst nightmare. I am a strong proponent of religious liberty, but I do believe the Religious Freedom Restoration Act is exactly the wrong means to achieve it. Now, before RFRA was passed, in 1990, the Supreme Court decided the Smith decision, which was mentioned before. Some of you may know it from the newspapers as the Peyote decision. In that case, the Supreme Court said that generally applicable laws that are neutral, in other words, that are not discriminating against religion, aren't targeting religions, do not require, as a matter of the Constitution, exemptions when they burden certain religious practices. So the court said, in effect, that if a law has been democratically enacted and the people have asked for such a law, that it will stand even though it burdens particular religious practices. If there is a burden, the court added, it is acceptable, so long as it doesn't violate the Establishment Clause, for the legislature or the city or the Congress to provide an exemption for the particular religious practice. So in other words, the court said that the political process could work out particular exemptions, but what we must be most concerned about is laws that target religions. In a later case decided in 1993, which was decided only 5 months before RFRA was passed, the court said that, in fact, if a law does target a particular religious community, that is unconstitutional. And when that happens, we will engage in heightened scrutiny. We will look at this law with great care. We will require a showing of compelling interest and the least restrictive means test, which is as high as it gets in terms of scrutiny. Now, 5 months later, after that decision, the Supreme Court, the Congress of the United States, almost unanimously passed the Religious Freedom Restoration Act. To understand what is going on in this particular law, you must understand constitutional history. I think Roger was right to start in that particular order. And let me begin by saying that if you look at the Constitutional Convention, the one word you will see over and over again is the word tyranny. The framers were absolutely intent on depriving this new nation of the possibility of tyranny, and they saw one place where tyranny resided as they looked back over history, and that is in concentrations of power. The framers agreed that the way in which to avoid tyranny was to divide and to decentralize power, and they did that by creating what they looked upon as a mechanism, this Constitution. It was supposed to be a watch with the cogs operating smoothly, or a solar system in which the planets were running smoothly. Now, the 3 most important structural safeguards in the Constitution are the separation of powers between the 3 federal branches, federalism, which separates power between the federal government and the states, and the Establishment Clause, or the Religion Clause, is taken together, which separates the power of church and state. That power, as separated, according to the framers, would prevent the sorts of tyrannies that had occurred in the past from the centralized power which is most noted in the union of church and state. Now, the Religious Freedom Restoration Act crosses all 3 of those boundaries simultaneously. No one, not even the respondents in this case, would disagree that the Supreme Court has the final word on the meaning of the Constitution. Once the Supreme Court has declared the meaning of the Constitution, that will be its meaning. No other branch has the ability to subvert that meaning. And I believe that Marbury v. Madison stated the problem with RFRA most elegantly, and it is a warning that we should all adhere to. The court stated, for Chief Justice Marshall, either the Constitution controls any legislative act repugnant to it, or the legislature may alter the Constitution by an ordinary act. Between these alternatives, there is no middle ground. The Constitution is either a superior paramount law, unchangeable by ordinary means, or it is on a level with ordinary legislative acts, and like other acts is alterable when the legislature shall please to alter it. If the former part of the alternative be true, then a legislative act contrary to the Constitution is not law. If the latter part be true, then written constitutions are absurd attempts on the part of the people to limit a power in its own nature illimitable, which is to say that if the Constitution does not place meaningful checks on the exercise of authority by the legislature, its authority will be boundless. Now, the purpose and effect of RFRA is evident in all of its legislative history and in its text. The Act states that even though the Supreme Court has declared in Smith that the Free Exercise Clause does not require exemptions, that does not cover enough of the free exercise of religion in this country as Congress would like. Rather, Congress will now institute a different rule, the rule announced before Smith was decided in Sherbert v. Werner and Wisconsin v. Yoder, and it will now reinstate that rule as the rule to be applied in cases in which there is a claim of a violation of the free exercise of religion. In other words, the Congress has decided that the court's Smith decision is not good enough as a reading of the Constitution, and that instead, Congress will now require the courts, when they hear free exercise cases, to apply two decisions that the court has expressly overruled and rejected. It's very simple. This is a bedrock constitutional violation. Congress has done nothing more than say that it disagrees with an interpretation of the Constitution, and it shall substitute its own reasoning for that of the courts. Now, to understand RFRA, though, you have to understand its scope. The Religious Freedom Restoration Act applies to every law in the United States, whether it was drafted and enacted by a city, a state, a municipality, the federal government, whether or not it is not a written law, whether or not it is a law because a government official has been acting under color of law. It applies to every law in the United States. It applies to every government in the United States. Cities are not exempted. States are not exempted. The federal government is included. And it applies whether or not the law was passed before or after the passage of RFRA. In other words, this act clearly intends to be the structural equivalent of the Constitution. No other law in this country has this scope. Congress has never tried to have a law in the past that had this scope. And its very scope is the prime indicator that what, in fact, Congress is trying to do is to displace the judiciary's decision with its own policy determination that a different standard ought to be applied in these cases. Now, what's the result of providing this heightened scrutiny, this requirement that governments now must prove, after they have democratically enacted a law, that the law must have a compelling interest and that it is the least restrictive means with respect to every individual religious believer? The upshot is a dramatic shift in the balance of power between church and state. And it is accomplished through the implementation of a bare standard of review that's yoked to no particular arena within which Congress has an enumerated power. Now you say to me, and I will take this as a very fair question, why should we hamstring Congress by forcing it to act within the confines of a particular enumerated power, when what we're doing is a good thing here? Liberty is a good thing. The answer is twofold. One, the framers fundamentally understood what we need to relearn in our own scheme, and that is that holding federal power to the enumerated powers is the only means in the Constitution that will adequately contain a federal branch that has the capacity to become illimitable. Secondly, the balance of power between church and state is extraordinarily important that it be balanced and that neither side have a particular hand up in any particular negotiation. In fact, in our particular case, the reason that there's no negotiated agreement is because under the Smith rule before RFRA, there was an even playing ground. After RFRA was passed, the church had such an upper hand that now that we don't know whether or not RFRA is constitutional, we don't even know what the playing ground is anymore. We don't know what the relative rights are. We require the Supreme Court to tell us what the relative rights are. Now, Section 5 of the 14th Amendment offers no cover for RFRA. Its language itself reveals RFRA's weaknesses. The following text-based reading of Section 5 is consistent with all existing laws and cases currently in effect. Here's the language of Section 5, very straightforward, quite short. The Congress shall have power to enforce, by appropriate legislation, the provisions of this article. What is meant by enforce? Enforce, if you look at the legal dictionaries at the time of the drafting of the 14th Amendment and in the late 19th century, the legal dictionaries say enforce means to compel obedience to. What is meant by provisions of this article? That's obvious. What's meant are the guarantees found in the 14th Amendment. So that Section 5 provides the power to enforce, compel obedience to, constitutional guarantees found in the 14th Amendment. And its power is limited by the fact that it must be appropriate. There must be some proportional fit between the means chosen and the constitutional end. Now, the Supreme Court has said that, in fact, Congress can act through a prophylactic means. In other words, it can make illegal that which is not constitutionally suspect if, in fact, Congress is trying to remedy a constitutional evil. The problem with RFRA is that it is not aimed at any constitutional evil. RFRA is directly aimed and was passed for the sole purpose of bringing into the constitutional fold that which is not constitutionally impermissible. It simply doesn't fit Section 5's language, and it's inconsistent with this Court's cases under Section 5, which adjudicate the Voting Rights Act and Title VII in large part. In contrast to those cases, RFRA attempts not merely to enforce, but rather to redefine constitutional guarantees. And no matter where you look, if you look at the legislative history, if you look at the text, if you look at the President's signing statement, in every case, it is clear the purpose of RFRA was to overturn, to override, to fix Smith, and to provide protection against laws that do not violate the Free Exercise Clause. Now, some have defended RFRA as an equal protection statute. That's an attempt to protect against discrimination against religion. And that is obviously a pretext to shoehorn this act into the equal protection jurisprudence. The statute is obviously over-inclusive if that is its justification. It's not aimed at discrimination. It makes discrimination irrelevant. You don't have to prove discriminatory impact or discriminatory intent under RFRA. All you must prove is a sheer burden. That is not a law against equal protection or for the purpose of enforcing equal protection, That is a law against burdens on religion per se, which makes it far beyond the free exercise contours. Now, finally, our third argument, the city's third argument, is that the Religious Freedom Restoration Act violates the Establishment Clause. You have to be very careful in trying to understand RFRA because its standard is a bit of a metaphysical statement. But what it means is the following. It sends a message of endorsement of religion over non-religion. It says that every religion in this country deserves to be elevated whenever it comes up against a generally applicable law. And implicitly it says that no other philosophical concerns also need be elevated. It makes every law in the United States presumptively invalid as applied to religious believers. Under Curios Joel, the decision by the Supreme Court, the court said that the Free Exercise Clause and the Establishment Clause must be read together, and I think that's sound. They said the state may not favor religious adherents collectively over non-adherents collectively, and there is no question that that is in fact what RFRA does. This law endorses religion, making religious believers feel like they are less than full members of the community because their philosophical claims will not get them around the law, while religious claims will in fact not only get them around the law, but get them in court and entitle them to steep attorney's fees. Now, finally, the Supreme Court, let's be fair to the Supreme Court, it's been a bit confused in the Establishment Clause context. They have been searching for the right standard. The one standard, though, that they keep using and that everybody keeps saying is no longer part of the lexicon is the Lemon v. Kurtzman test. Under the Lemon v. Kurtzman test, RFRA is not constitutional. And the reason it's not is because it privileges religion over all other entities in the society. But most importantly, it requires entanglement. The least restrictive means test requires the following. It requires a government, a responsible government, as it's enacting a law, to figure out whether or not the law that it's drafting will in fact impinge on any religious believer in their community. Now, how is a government going to know that, right? There's only one way for the government to have an answer to that question. The government is going to be forced to keep records of what religious believers reside within the community. But worse, in my view, they're going to have to understand their theological tenets. It's impossible to craft a law not violating the least restrictive means test, except in ignorance. Now, the Coalition for the Free Exercise of Religion has defended against this entanglement claim on the grounds that, well, governments can go along being blind, as they've always been, and just regulate wherever they want. And then all they have to do is when a RFRA claim is raised to them, then they just have to make an accommodation, right? But that is not a fair characterization of what the governments in this country are now experiencing. What happens rather is that a lawsuit is filed under RFRA against the government. If the government makes any concession of any kind in response to the request for accommodation, that government is now liable for attorney's fees. And as you know, as many of you I'm sure are intimately familiar with, attorney's fees can be quite steep. It would be irresponsible for governments to enact laws in the regime of RFRA without being fully aware of their consequences on the particular religious believers that live within their communities. Finally, with all due respect to the organized religions in this country, I am a religious believer who takes a Calvinist approach to organized religion, as did the framers. The appearance of the major organized religions coming together to draft a statute for Congress, to lobby for it, and then to litigate it to the hilt through the courts simply makes me nervous. In Larkin v. Grendel's Den, the court said that the mere appearance of a joint exercise of legislative authority by church and state has the primary effect of advancing religion. There's not much question in this historical circumstance that the organized churches in this country have come together with the most dangerous branch, the Congress, in order to elevate the power of them within the community. This is the very union of power between church and state that was most feared by the framers. If RFRA is upheld, we can simply install a moving sidewalk between the court and Congress so that when the court issues constitutional interpretive decisions, the losers not on the law, the losers not on the merits, but the losers on the interpretation of the Constitution can now more easily reach Congress to overturn that interpretation. We can also expect an onslaught of federal control of local and state lawmaking in every arena. The text of the 14th Amendment refers to privileges and immunities, equal protection, and due process, including life, liberty, and property. The expansive reading of the 14th Amendment suggested by the church and the federal government in this case would eviscerate the liberty that is preserved when local communities have a measure of autonomy from a distant and a centralized national power. RFRA threatens to erase local autonomy and to cement the unfortunate expanse of federal power that has occurred over the last half-century. Yet, let me add a bright note. I do have confidence that the court will do the right thing in this case and will declare this unusual usurpation of judicial and state authority in violation of the United States Constitution. Thank you.
Thank you, Professor Hamilton, and thank you for coming in on time. We're now going to hear from Mr. Kevin J. Hassan, Seamus as he is known to his friends, who is the founder and president of the Becket Fund for Religious Liberty. That is a bipartisan and ecumenical public interest law firm that protects the free expression of all religious traditions. The Becket Fund is, for example, currently suing the Department of Defense on behalf of a coalition of Christian, Jewish, and Muslim plaintiffs in a challenge to DoD directives censoring military chaplains' sermons on political issues. Mr. Hassan is a noted religious liberties lawyer. In 1986 and 1987, he served in the Department of Justice, Office of Legal Counsel, where he specialized in church-state issues. From then until founding the Becket Fund, he was in private practice at Williams & Connolly, a distinguished Washington law firm, where he likewise concentrated on religious liberty matters. Mr. Hassan is a 1985 magna cum laude graduate of Notre Dame Law School, and he also holds a master's degree in theology from Notre Dame. Would you welcome, please, Mr. Kevin Hassan.
Thanks, Roger. Thanks, Tim. Professor and I agree that religious liberty is important. Professor and I agree on virtually nothing else. Even more liberty. The Religious Freedom Restoration Act is constitutional because it gives people in the United States even more liberty. It takes from both the federal government and the state government authority and gives even more liberty. Giving even more liberty than the Constitution requires is a perfectly respectable thing to be doing under Section 5 of the 14th Amendment, and RFRA is therefore constitutional. But let me digress for a moment, and I mean digress because I'm going to discuss whether RFRA is a good idea. I think it is. Professor and I disagree about that too. But whether it's a good idea has got nothing to do with whether it's constitutional. There are all sorts of crummy ideas that are constitutional. There are all sorts of good ideas that are unconstitutional. This is a good idea that happens to be constitutional, but I'm digressing precisely because those two propositions are really not related at all. The case the professor referred to that was handed down shortly before RFRA was passed, the case of Lukumi Babalu I. It was a case of good old-fashioned religious persecution. And it is very instructive what it took to remedy that persecution. Probably one of the more despised religions in America, that of Santeria, was in trouble in Hialeah, Florida, because Santeria requires its adherents to sacrifice small animals. Hialeah, not surprisingly, didn't like the sacrifice of small animals, and banned them in so many words. After this was passed, in Hialeah you could hunt where appropriate, you could fish, you could trap mice, and you could boil lobsters live. The only way you could not legally do in an animal in Hialeah was to sacrifice it. Congress had gone, or the legislature in Hialeah had gone right after a religious practice, precisely because it was a religious practice that they didn't like. 6 years of litigation later, after every judge of the lower courts had said, oh, this is a neutral law of general applicability, the Supreme Court remedied the situation. But only 6 years later. And it took the Supreme Court itself to correct what was clearly an error of all the lower courts, that a law targeting sacrifice is not a neutral law of general applicability. It is not as if people get up in the morning and say, what should we do today, dear? I know, let's go sacrifice a chicken. It's directed at religious liberty and only religious liberty. What else does RFRA do other than rectify good old-fashioned religious persecution? Well, this case is a perfect example. The city of Boerne wants to control the number of worshipers that fit inside a church. St. Peter Church is just not big enough for its congregation anymore. And the church, behaving sensibly, wants to build a bigger church on its own property. But the bureaucrats of Boerne said no, that they like the church exactly the way it is. And the bureaucrats of Boerne are not satisfied to argue that they have a compelling interest in managing the decor of other people's churches. They are, in the Supreme Court of the United States, arguing that the most important grant of religious liberty, probably since the Free Exercise Clause, is unconstitutional as applied to every possible example in the United States. That is, they would rather see the statute burned to the ground everywhere than lose their own small little bureaucratic fiefdom. That is a perfect example of what is even a greater threat to religious liberty than the good old-fashioned kind that was at issue in Lukumi Babaluai. I will give you 2 more examples, and then I promise to return to why it's constitutional and not just a good idea. One is a case called Grosh versus City of Miami Beach. And this is a particularly interesting case because it happened in 2 phases, one before RFRA and one after RFRA. In Grosh, an Orthodox Jewish rabbi wanted to hold a minyan, effectively a prayer meeting, in his home, and was told by the powers that be in the city of Miami Beach that he could not do so. It violated the zoning requirements. He sued. The court said, I'm sorry, this is a neutral law of general applicability. You and your minyan may not pray in your home. Then RFRA was passed. The rabbi sued again. The district court again said, I'm sorry, but the Court of Appeals reversed and said, no, RFRA goes ahead and protects what Smith did not. And then there's the case that Roger referred to that the Beckett Fund is bringing. We're suing under RFRA as well as under the federal Constitution. The Defense Department's denial of freedom of speech and religion, the freedom to preach to a broad coalition of Christians, Jews, and Muslims. The Defense Department, under a neutral law of general applicability, has told them that they may not preach against Clinton's veto of the partial birth abortion ban and in favor of Congress's override of it. I do not want to say, but for RFRA we would lose, because I do not believe that to be true. But RFRA is clearly the strongest argument. Now, meanwhile, back at the ranch, RFRA is constitutional because it grants even more liberty. Why in the world should a statute be allowed to grant even more liberty? Because That is what Section 5 of the 14th Amendment was clearly designed to do. 14th Amendment, as the 13th and 15th Amendment like it, was passed by the Reconstruction Congress in the wake of the Civil War. The 13th Amendment abolished slavery, the 15th Amendment guaranteed voting rights, and the 14th Amendment did three things. At least it was designed to do three things. Section 1 was designed to do three things. One was to guarantee equal protection of the law. One was to prohibit states from denying life, liberty, or property without due process. And the third was to prohibit states from denying to citizens the privileges or immunities of United States citizenship. In each of these amendments, Congress did a remarkable thing, something that no previous amendment had ever done. It granted enforcement rights to itself in essentially identical language in all three amendments. There's a very important reason it did that. The reason it did that is it did not trust the Supreme Court to enforce the three amendments. The reason it didn't trust the Supreme Court was it had just lived through a civil war, and the Supreme Court then sitting was virtually the same court that had handed down Dred Scott. Congress simply didn't trust it, so, as Congress was certainly empowered to do, it proposed a constitutional amendment that gave the Congress a very substantial role in enforcing, and that is the word that it used, each of these three amendments. The amendments, of course, were ratified and went on to become, some think, a good idea, and some think a bad idea. There are people who believe the 14th Amendment is disastrous. I'm not one of them, but there are people. That grant of enforcement power to Congress, specifically because it did not trust the court, is what is at issue in this particular case. On the day that the 14th Amendment was, the revised draft, the eventual draft of the 14th Amendment was introduced, Senator Howard, who introduced it, had this to say, and it's lengthy, but it deserves quoting in full. Now, sir, there is no power given in the Constitution to enforce and to carry out any of these guarantees. The guarantees he was speaking of explicitly were the first 8 amendments to the Constitution. They stand simply as a Bill of Rights in the Constitution without power on the part of Congress to give them full effect, while at the same time the states are not restrained from violating the principles embraced in them. Up until that time, the Bill of Rights were limitations only on the federal government, not the states, and the court, not the Congress, had any power to do anything about them. As I have remarked, they are not powers granted to Congress, and therefore it is necessary, if they are to be effectuated and enforced, as they assuredly ought to be, that additional power should be given to Congress to that end. This is done by the 5th section of this amendment, which declares that the Congress shall have power to enforce by appropriate legislation the provisions of this article. Here is a direct affirmative delegation of power to Congress to carry out all the principles of all these guarantees, a power not found in the Constitution. Congress knew precisely what it was doing. It was giving itself the power to do what it did not trust the court to do, to carry out, enforce, and effectuate all the principles of all these guarantees. One of the specific problems that Congress was worried about, and the debates at the time are replete with references to it, the religious liberty of people in the South, both freed slaves and abolitionists, including under laws of, guess what, general applicability. Laws like noise regulations. Southerners had invoked noise regulations to suppress the religious meetings, this is a quote, religious meetings among the colored people. Planners proposed regulations authorizing only ordained ministers to preach and imposing A 10 o'clock curfew on meetings. Sounds a lot like a zoning regulation in Miami Beach. It's not only all the laws that Congress was worried about, or all the provisions of the Bill of Rights that Congress was worried about. It was those with particular emphasis on religious liberty. Now, does enforce simply mean punish? No, it means impose prophylactic laws that go beyond what the Constitution itself requires. How do we know that? There is a long string of Supreme Court cases, not only under the 14th Amendment, also under the 13th and the 15th, and actually under some of the others as well, because when Congress began to give itself delegations of power in the 13th, 14th, and 15th Amendment, not surprisingly, it thought it was such a good idea that it kept doing it. It did it again in the 18th, 19th, 23rd, 24th, and 26th Amendments. Now, previous legislation passed by Congress in the teeth of Supreme Court cases shows that RFRA is no different. Let me pause for a second to say, is it troubling for Congress to give itself this much authority? Sure it is. Anytime you give Congress authority, it's troubling. They tend to do dumb things with it. Nevertheless, the Constitution is what the Constitution is. Section 5 says what it says. So, the Voting Rights Act, which many people in this room think was a dumb idea, is passed largely by under Section 5 of the 14th Amendment. It prohibited, among other things, literacy tests and voting. The Supreme Court had said unanimously the 14th Amendment does not prohibit literacy tests and voting. Congress came back explicitly in the teeth of that opinion and banned literacy tests and voting, and the Supreme Court upheld it under Section 5 of the 14th Amendment. And more than once, I might add. Various other provisions of the Voting Rights Act are the same. Title VII's application to state and local governments passed solely under Section 5 of the 14th Amendment. So, when the Supreme Court says that pregnancy discrimination, for example, is not sex discrimination in violation of either the Constitution or Title VII, it is doing for sex discrimination what it did for religious liberty in Smith. And when the Congress then comes back and bans pregnancy discrimination against state and local governments under Title VII, Congress is doing for sex discrimination what it did for religious liberty in RFRA. When the Supreme Court says that the Constitution bans only deliberate discrimination and not disparate impact, but Congress comes back and bans employment practices, or at least requires them to be justified under Section 5 of the 14th Amendment, Congress is doing for all types of discrimination what it did for religious discrimination in RFRA. There is no difference. The federal government is a much easier case. It's a much easier case because Congress has not done any such thing as interpret the First Amendment. The Congress, in doing all that I've described so far, has simply interpreted Section 1 of the 14th Amendment under its powers as Section 5. In banning the federal government from infringing religious liberty, in giving even more liberty to the people, Congress is acting under the Necessary and Proper Clause of Article 1. The Necessary and Proper Clause allows Congress to do anything necessary and proper to effectuate the powers of Article 1. And the analysis is really very simple. Any statute that Congress can pass, it could simply attach an accommodation, a religious accommodation statute to. It can do it to the entire federal code all at once. It's in the same way. Now, as for the Establishment Clause, the Supreme Court held in a case called Corporation of Presiding Bishop versus Amos that there is nothing wrong with Congress. That upheld the religious accommodation provision of Title VII. There is nothing wrong with Congress giving accommodation to religious believers, and specifically said there doesn't have to be some sort of countervailing accommodation for non-religious believers. Lastly, if the least restrictive means test in Smith violates the Establishment Clause, or in RFRA violates the Establishment Clause, then Smith itself violates the Establishment Clause, because Smith retains exactly the same test for hybrid sorts of claims and for claims that target a religion in general, or in specific. If you can do that under Smith, then you can do it under RFRA as well. In sum, the federal government and the state government are equally restricted by RFRA, which gives people even more liberty. It's why it's constitutional. It also happens to be why I believe it's a good idea. Thank you.
Thank you, Kevin, and thank you also for coming in on time. I neglected to mention in my introductory remarks for Mr. Hassan that he has filed an amicus brief in the Supreme Court in this case on behalf of the Beckett Foundation, as well as a number of co-parties to the amicus brief. We're now going to have 5 minutes of rebuttal from each of our speakers, starting with Professor Hamilton, then with Mr. Hassan, and then we will open it up to questions from the floor. Professor Hamilton?
I think you can understand now why I started out by saying that the problem with this law is that it violates any respect for the rule of law. Mr. Hassan stood up here and complained about the bureaucrats of Boerne. The bureaucrats of Boerne are the duly elected officials elected by the people of Boerne, who are carrying out the plans that the people of Boerne have asked for. The historical preservation law that is in effect in Boerne has been in process for over 15 years. It has nothing to do with this particular case. It is simply the will of the people of Boerne. In Justice Scalia's recent book, talking about the interpretation of the Constitution, he made a very important point in trying to understand what even more liberty really means. He said that every right requires a sacrifice on someone else's part. That is exactly what we're talking about with RFRA. If RFRA is good law and can be applied to every city, every state, every law that they pass, then what it means is that the people cannot, through their duly enacted and elected representatives, cannot set the agenda for their communities. There is less liberty overall when federalism is completely stomped out by the ability of a centralist government to determine what the level of liberty will be in every community. Federalism is at stake in this case, and it is at stake because those who have drafted for, lobbied for, and are now litigating RFRA firmly believe that elected officials are nothing but bureaucrats. That is simply inaccurate. Now, I'll be the first, as Jerry is fully aware, to talk about the executive branch as being filled with bureaucrats who don't do the right thing. But that's not what we're talking about here. We're talking about duly elected officials. Secondly, the problem with RFRA was conceded in Mr. Hassan's first point. He stated that all this does is provide even more liberty than the Constitution requires. That's true. That's its problem. Under Section 5 of the 14th Amendment, and every case in which this court has upheld an exercise of Section 5, the court has said that the law enforced constitutional guarantees. If it was prophylactic, in other words, if it was to some degree an over-regulation, it was only for the purpose of enforcing constitutional guarantees. There is no way to fit RFRA into that particular corner. RFRA does not attempt to enforce constitutional guarantees. It attempts to enlarge them dramatically with respect to every law and every government in the United States for the purpose of imposing Congress's policy views on religious liberty on the courts and on the states. It is dramatically different than anything the court has ever said was appropriate. Finally, the defense that the court has already said that this is okay in the Amos case, in which the court said that it was appropriate for the government, the federal government, to exclude churches from the reach of their anti-discrimination and employment provisions, is simply indefensible. In the Amos case, the court ruled that there was no entanglement problem because it was an actual exemption. It took religions out of the picture altogether. That is the opposite of what happens in this scenario. Under the Religious Freedom Restoration Act, for a government to know whether or not its law is going to be protected from challenge in the courts and protected from the extraordinary fees that are the result of those sorts of challenges, the local government, the state government, and the federal government must figure out whether or not it is going to violate particular religious believers' beliefs. And it can't do that without entanglement. So Amos is completely dissimilar because the entanglement problem won't go away. And finally, the notion that the least restrictive means test appears in Smith, and therefore it's safe from Establishment Clause scrutiny, doesn't deserve much comment. It appears in Smith in a very narrow range of cases. With RFRA, we're talking about a requirement that every government in the country be aware of every religion within every jurisdiction. That's a very different scenario than the Smith court painted in its very narrow holding. Thanks very much.
Well, even assuming that bureaucrats tend to affect the will of the people, a charitable assumption I'll make probably for the first time in my life, the will of the people is simply not the end of the matter. We do not live in a pure democracy. The Bill of Rights was designed specifically to prevent the will of the people from accomplishing certain things. The 14th Amendment was passed specifically to prevent the will of the people, particularly in the southern states, from accomplishing a great many things that Congress thought was evil, including trampling on religious liberty. What the professor seems to be arguing is that Section 5 is a bad idea. Maybe it was a bad idea, but it is the Constitution. And bad idea or good idea, it is there to be enforced. What the difference between a prophylactic rule that enlarges it a little bit and something that enlarges it dramatically is left unsaid, and I confess I don't know the answer to that either. I think prophylactic rules that enlarge religious liberty are specifically within the domain of Congress to decide. That is what Section 5 was all about. As for Amos and entanglement, there is no entanglement requirement in Smith. Smith does not require every statute that's ever drafted to include its own religious exemptions. Smith simply makes those statutes inapplicable in the absence of a compelling interest to religious believers whose consciences require otherwise. The state doesn't have to figure out what Buddhism provides for, what Catholicism provides for, and so forth before it passes every statute. It simply passes its statute. And just as in the pre-Smith regime, the conscientious objector then comes along and says, I'm sorry, I cannot do that. It violates my conscience. At which point the state either says, fine, go ahead and build your church, or the state says, well, I'm sorry, but we have a compelling interest that is narrowly tailored. The state doesn't have to do that in all circumstances, and one would hope that it does not. In fact, one good way to judge a law is not by how many lawsuits are filed under it, because laws are not in the first instance passed to be fodder for lawsuits. Rather, laws are passed to be obeyed. And one would hope that simply as a matter of democracy, in the Supreme Court in Smith, the majority in Smith, thought as a matter of democracy, that religious freedom should be respected in the legislative process. To the extent that the Congress and the state legislatures go ahead and do that, they're behaving in the best of our tradition. They're doing something noble and praiseworthy. It's not entanglement. To the extent that they do not, and simply go ahead and legislate, and then after the fact either grant exemptions or decide to try and burn down Western civilization and go to the Supreme Court instead to protect their zoning regulations. RFRA is there. In neither case is it an entanglement. And as for the fact that in the Smith only allowed for a narrow range of cases for the least restrictive alternative, that's true. But I thought the professor's point was the least restrictive alternative itself violated the Establishment Clause, and that shouldn't depend on how narrow the range of cases is. Thank you.